Black women are already more than 3 times as likely to die giving birth than white women. Can you imagine that number climbing even higher? One Supreme Court decision could tragically push that maternal mortality rate up by another third. And that's just ruling number 1. Today we're diving deep into 3 recent Supreme Court cases that, under the guise of colorblind logic, are quietly but systematically dismantling Black health, wealth, and political power. Are you ready to see the alarming pattern that connects them all? Last summer, the court officially overturned Roe v. Wade, throwing reproductive rights into chaos. Almost immediately, states across the nation rushed to ban or severely restrict abortion access. For Black women, the fallout from this decision is nothing short of brutal. We already grapple with disproportionate healthcare access, facing more clinic closures in our communities and struggling with less comprehensive insurance coverage. Compounding these barriers is the tragic reality that Black women endure the highest maternal mortality rate in the entire nation. Researchers, including those at Duke, have calculated that a nationwide abortion ban isn't just an abstract policy change. It would directly raise pregnancy-related deaths for Black women by an additional 33%, with some studies estimating up to a 39% increase. What does that translate to in real terms? More sepsis? More strokes? And heartbreakingly, more funerals for mothers who shouldn't have to pay the ultimate price. To make matters worse, OB/GYN residencies are drying up in states with strict abortion bans, exacerbating an already critical provider shortage. The grim result? Comprehensive reproductive care transforms from a basic right into a luxury item, and Black women are forced to pay the highest price, sometimes tragically, with their very lives. This isn't just about healthcare, it's about life and death. Just 1 year before the Roe decision, the court delivered another blow, striking down race-conscious college admissions. While some conservatives champion this as fairness, economists and civil rights advocates are calling it what it truly is: a gatekeeper slamming shut on the path to the middle class for Black Americans. We've seen this play out before. In states that banned affirmative action years ago, Black enrollment at top public flagship universities already dipped by as much as 30%. Fewer elite degrees don't just mean fewer opportunities, they translate directly into significantly lower lifetime earnings. We're talking about a potential loss of about $500,000 over a career for individuals. Now, multiply that across a generation of Black students denied access to these vital institutions, and you're looking at a staggering $100 billion wealth stripping from Black communities. Think about it. The tech, finance, and law sectors still heavily recruit from those same elite campuses. So, this ruling isn't merely changing the racial makeup of college campuses. It's fundamentally rerouting the pipeline to power, influence, and capital, further entrenching economic disparities for generations to come. Now, the Supreme Court has its sights set on Section 2 of the Voting Rights Act, a cornerstone of civil rights legislation. In the pivotal case of Louisiana versus Calais, the justices are grappling with a deeply troubling question. If lawmakers consider race when drawing a majority Black district to ensure fair representation, does that somehow discriminate against white voters? A yes vote here wouldn't just be a minor legal adjustment. It would effectively legalize racial gerrymandering nationwide, potentially gutting the VRA's most powerful remaining provision. We've seen this movie before, haven't we? Back in 2013, the Shelby County versus Holder decision trashed the pre-clearance provision of the VRA, unleashing a wave of voter suppression. In its wake, states previously under federal oversight closed at least 868 polling sites, with later reports indicating over 1,600 closures, many concentrated in predominantly Black counties. When you systematically diminish Black representation in state legislatures and Congress, you're not just moving lines on a map. You're silencing the very voices that fight for better hospitals, advocate for fair lending practices, and champion living wages. Health and wealth setbacks don't happen in a vacuum. They're locked in when Black voters lose their rightful seats at the policy table. If this all sounds like a deeply coordinated play, a deliberate strategy to roll back decades of progress, that's because it absolutely is. Hit that share button. Let's make sure the algorithm shows this to everyone who still believes the court is just calling balls and strikes, when it's clear they're rewriting the rules of the game. What ties these 3 seemingly disparate rulings together? It's the same insidious legal logic: colorblind constitutionalism, weaponized. The argument goes that any race-conscious fix, even one designed to remedy generations of systemic discrimination and level a fundamentally uneven playing field, is itself a form of discrimination under the Equal Protection Clause. This interpretation conveniently ignores the historical and ongoing realities of systemic racism, pretending that simply ignoring race will somehow create equality. The court isn't erasing race from American society, it's erasing the essential tools we've used to address racial inequality and build a more just society. The end result? Black maternal mortality numbers tragically climb, household wealth for Black families stagnates or even declines, and our political maps threaten to regress to pre-1960s Jim Crow-era math. One ruling chips away at our foundations, 2 rulings crack the very bedrock, and now, 3 rulings threaten to bring the whole house down, undoing civil rights gains that took generations of struggle to achieve. So, here's the stark trifecta we're facing: abortion bans that directly raise the death rate for Black mothers, admissions bans that shrink lifetime earning potential and access to opportunity, and voting cases that aim to mute our collective voice in the democratic process. Each of these decisions might be couched in neutral legal language, but let's be clear, their outcome is anything but neutral. They are designed to disproportionately impact Black communities. If you genuinely care about Black health, it's time to get active. Start tracking state bills on maternal care, and advocate for policies that support Black mothers. If you care about Black wealth, support scholarship funds and initiatives that are actively replacing the race-conscious seats the court so carelessly erased. We need to build new pathways to economic opportunity. And if you care about Black power, you must vote in every single down-ballot race, from school boards and judges to county clerks. Why? Because redistricting, the silent architect of political power, happens in the weeds of local politics. The Supreme Court has spoken its piece. Now, more than ever, it's our turn to stand up, speak out, and fight for the future we deserve.